All right. Good afternoon. How are we doing today?
Hi, sir. We're fine. How are you?
I'm I'm hanging in there. Okay. So to get started, right? The first thing that I want to do is I want to talk about um, what you guys feel like you learned last week, and this is just a check-in to make sure that you guys uh, feel that you guys feel like you've taken away what you need from last week's lectures and that we've clarified anything that you're confused about. Okay, so what did we learn last week in the lecture?
Hello. Do you hear me?
Go ahead, Kami.
Oh, yeah. Last week was this. Did we speak about the ancestors
Hang on. I need to go ahead.
I said last week, I think we spoke about the ancestors and the comparators. Yes, that's what we talked about last week.
I'm sorry. Say that again. Kami, can
Okay.
you go ahead?
If last week we spoke about the ancestors and the comparators, stuff like that.
Does anybody else want to take a so I'm a little concerned. Kami,
Sir, we're talking about Judy of
I'm sorry, Kelsey.
Sir, weren't we talking about Judy of Kier?
Yeah, that was yeah that was what I lectured on last week. But I'm a little concerned. I'm not sure what Kemi's talking about, and I want to make sure that we're all on the same page. So, Kemi, can you expand on what you mean so that we can make sure that we're all understanding one another? Oh, okay. You were mentioning the specific tests. I heard something very different, and that had me concerned. So I apologize. Thank you for clarifying in the chat. I wasn't sure what the first thing you said was, but the second thing I heard was comparators, and to just sort of put that in the chat for everybody, what I heard was comparators, and that had me very concerned because that's something that we do when we're doing tort litigation is we're concerned about comparators in certain types of cases, but we aren't there yet, and we aren't going to get there in this class. You may not get there in torts too. So exactly. So this was why I was concerned, is that I was not sure what where you had drawn this from. Um, so I apologize, but yes, everybody who has discussed this in the chat or has come off mute and said something in voice, you're all correct. The duty of care is exactly what we're talking about. So, what questions did you guys have about that before we get into this week's discussion?
So I just wanted to clarify, right?
Mhm.
if it have a specific time we're supposed to use each test. Like I can't remember if we established like when you're supposed to use the comparators or when you're supposed to use the answers.
Right. So the answer to that is that these represent doctrinal evolutions. Okay, so there's not a class of cases that uses ands and a class of cases that uses Caparo. There's a period of time where the ands test is the one that we're using. Then Caparo comes along and says, well, we're going to refine the test and we're going to use it differently. And then, if you recall, the Cotellini book, the Caribbean book, sort of ends at Caparo. But if you go and you look at the worksheet or you look at some of the English textbooks that are recommended as resources, you find that there's been a further evolution since Professor Cotellini last revised Commonwealth Caribbean tort law. And that's the Robinson test that stops claiming to be a test at all, right? And says we're going to sort of unfetter the discretion of judges in deciding whether a new duty of care exists, but we're going to require them to do so incrementally by relation to the prior precedent, right? We're not going to let judges sort of freewheeling engage in policymaking. So, so okay. So does that answer your question, Kimmy, Kami? And also, please tell me how to pronounce your name so that I stop getting it wrong.
It's Kami.
Kami.
Right.
Okay.
And yes, it answers the question.
Great. Okay. So unless there's something else that folks are concerned about with the duty of care, let's talk about today's question. And today's question is actually reaching back 2 weeks into the lectures for the very first week of class, where we're just sort of taking this very 30,000 foot overview of tort law. And let me put, so you were asked to prepare to discuss both sides of a proposition, right? Both to argue that the proposition was correct and to argue that it was wrong. And the proposition is that contract and criminal liability sufficiently deter negligent conduct without the need for independent causes of action in tort. Okay, so does anyone want to jump up and down and volunteer their argument for why this proposition is correct? And I should warn you guys, right? That's the harder argument. So if you feel like that's a weaker argument, yeah, it probably is, and that's okay. But that's where I want to start. Okay? So who wants to offer up their argument? This is drawing on the worksheet 1. But I should warn you guys that my classes scaffold. So I don't make any promises that when we move on to worksheet 2 or 3 or whatever, that we won't come back and talk about things that are on worksheet 1, right? You don't lay things aside in my class, you build on them. So fair warning on that. This is drawing on worksheet 1. The actual question itself is in eLearning's website. It's in the block for this week, and it's the page marked tutorial questions. So, Okay,
Can I give it a try?
go ahead, lay it on me.
It might not be the best, I'm just saying. But if you look at criminal law focuses on deterring bad behavior. So tort, in a similar sense, is telling you, well, you're not supposed to hurt your neighbor. Criminal law is also telling you you have a responsibility not to hurt your neighbor. So therefore, why do you need to have a duality in law when you can just focus on that sense? And then
Okay.
with criminal law, you do get redress in the fact that they do penalize the person that hurt you. So they either get sentenced, they get fined. It might not come back to you, but at the end of the day, you still get some type of hearing.
Okay. So the argument is that criminal liability and tort liability basically engage, right, the same sort of deterrent, right? The idea is these are things that we have decided you, Mr. Tortfeasor or Miss Criminal, will not do. And if you do them, these are the consequences. But why do we have to have two sets of consequences, right? Is that your argument, Jade? Right? There's no reason to have two sets of consequences here.
Yes, please.
Okay. Okay. Anybody else want to expand on that or add another thought to this side of the argument, right? To the argument that we don't need independent tort causes of action. No, you feel like this is sort of the best you can come up with, or all you can come up with. And yes is an acceptable answer to that question. I'm just making sure that there's nobody out there sort of waiting to jump in. Okay. So what do we think about the other side, right? What are our responses to Jade's argument? What do we think is the reason why this statement is wrong, that we need independent tort causes of action?
I was thinking because contracts can be broken and sometimes the punishment for criminal liability is not as heavy. So people would think that it's just like an easy way to get off or something like that.
Yeah, right. So, going back, right, Oliver Wendell Holmes said that a contract is nothing more than a promise to pay damages in the event of breach, right? So Holmes would argue that there's no deterrent power to a contract. All it does is impose upon you a choice that you can either perform or pay, and you get to choose which side you want to fall on, right? So that's absolutely right. And then on the criminal side, right, have any of you ever heard the saying that if you punish a crime with a fine, what you're doing is making that legal for rich people? Ever heard that before?
No.
Yeah, it's kind of floating around in anti-carceral circles, right? Folks who sort of think that we should get rid of prisons and wipe a lot of criminal statutes off the books, and we don't have to get into that conversation. It's not really important. But the key piece of this is, right, that if what Parliament does when they create a criminal statute is they say, okay, you will pay X amount of dollars if you violate this statute, then what they have done is they have created a crime that only applies to poor people, right? Because in order for X to be, X being the fine, in order for that to be something that isn't a, sort of a crushing blow to a poor person, it has to be small enough that it could theoretically be paid, right? So if you, for example, if you want to impose a speed limit on driving, right? And you say that violating the speed limit imposes a fine of $10 for every kilometer per hour that you're over the speed limit. What you are saying is that someone sufficiently rich can drive at any speed and just say, whatever, I'll pay for it. Right? You are only deterring misconduct of poor people. Right?
But sir,
Go ahead, Jade. Go ahead.
at the same time, can't you say that the same poor people that would go for tort, you're only going to have a tort case if the plaintiff decides that they want to file a tort case. So there's still a deterrent in the sense of price if you want to think about it, because you have to have money to be able to go through that litigation process for however long it is, pay for the filing of the documents and so forth. Whereas if you leave criminal law or contract law, it more falls on the side of the state to look at all those pricings and to do it for you. So tort is basically still an expense at you
Yeah.
more
I
than
think,
criminal law contract would be.
I think that's absolutely right. And I think that is a really nice illustration of the difference in the systems that you guys are being trained to work in and the system where I was trained to work in. Because in the system that I was trained to work in, the vast majority of personal injury cases, of tort cases, are brought on what's called contingency fees. So if you guys turn on the TV and you turn on to one of the Miami stations that they use, you'll see ads for lawyers, and you guys may also find that disturbing, but it's very normal in the United States. And a lot of those ads will say things like, "We don't get paid unless you win," and that's how tort becomes a way to get recompense even without pre-existing resources, is that lawyers are entitled to, in the United States, are entitled to take cases, and instead of getting paid by their client, they get paid as a percentage of the recovery. Okay. And I think, if I remember correctly, I believe the Caribbean also follows the British rule of the loser pays, so that there's an additional deterrent for plaintiffs who may not have resources of, if you lose, you may have to pay the other side's attorney's fees, right? So these are institutional choices, right? These are procedural choices that affect the substantive law because it changes who can bring a case. Okay, and there's some interesting work related to dispute generation that looks at how those different rules affect the choices made by plaintiffs. So that's relevant. That's the kinds of things that I research. So there you have it. But yeah, I think that's absolutely right, Jade, is that, there are legitimate reasons to say that we would prefer the state to be to have the primary responsibility for enforcing the duty of care. But I want to ask, there are some questions that I think that raises, and I think that Destiny, picked up on a couple of them, but I want to ask a couple others, right? So, what is the burden of proof in a criminal case? What is the burden of proof in a criminal case? Jade, I appreciate your willingness to jump in, but let's not let your classmates off the hook. So I'm gonna ask you to let someone else answer this one. So, but I have no doubt that you would be correct. So what's the standard of proof in a criminal case?
That the party is guilty beyond reasonable doubt.
Right. Exactly right. So what is the standard of proof in a torts case? Now, we have not discussed this in this case, so if we have a long silence, I will just give you the answer, but I want to give you guys a chance.
Um,
Go
The
ahead.
claimant has to establish his claim on the balance of probabilities.
Right. The balance of probabilities, right? I see Andisha in the chat as well. So that's absolutely right. Okay. And so, you know, the balance of probabilities means that it has to be more likely than not. So what I used to tell my clients is that we have to get to the point where we have a coin flip between us and the defendant, and then we need anything more beyond that coin flip, right? Something more. And that's enough to prove the case. That's what the fact finder has to determine. Okay, is that we have 50-50 plus something. Okay, so sometimes you hear it referred to as 51% probability. And I am here to tell you that that is absolutely correct. 51% will get you there, but you can have less than 51%, right? Anything above 50% meets the balance of probabilities. So what we have here, right, what we have is in criminal law, we have this very high standard, beyond a reasonable doubt. Don't ask me to put a number on it, because every time I've heard someone say, well, it's, you know, that means 75% certain or 90% certain or 99% certain, I hear someone else go, no, that's wrong. So I've stopped trying. Beyond a reasonable doubt, very high standard. Somewhere below that standard is the balance of probabilities, 50% plus something. So what we have is we have all the cases where the burden of proof, right, the probability that the claimant's case is correct, falls somewhere between the balance of probabilities and beyond a reasonable doubt. So if we move the enforcement of tort liability into the criminal sphere, all of those cases that fall into that gap will fall by the wayside, right? Instead of being held liable in tort, those tortfeasors will be acquitted of crimes. Does that seem right to you guys?
Sorry, you can repeat, please.
Sure. So what happens is all of the cases where the balance of probabilities is met, but not beyond a reasonable doubt, these are cases where the defendant would be held liable in tort, but they would be acquitted of a crime. So does it make sense to you that we would only move things toward criminal liability if that's the change that we induce? Kimmy says no. Destiny, what were you going to say?
I was gonna say no.
Okay. Why do you guys say no?
Because tort and criminal different, and they both follow different. They both have different rules and guidelines that they have to follow. So I don't understand it. I think
Well,
looking at your face, I can see that I'm confusing you.
No. So this is a hypothetical. It's a counterfactual. We're saying, okay, we're going to do away with tort. We're going to eliminate private rights of action in tort. Instead, the state is going to bring criminal cases in situations where, under the status quo, tort would be allowed. Okay, so given that we're going to lose all of these cases where tort liability would be imposed, but you can't prove liability beyond a reasonable doubt, so criminal liability would not be imposed. Okay. Given that, do we think that this is a good policy choice? And I'm hearing, you know, Cammie says no, but Jade is saying that we still have negligence and recklessness in the criminal law. What do we think? Are we thinking or are we just confused? Okay. Well, tell you what, let's take a minute, think, make some notes, and then we'll come back and we'll hear from you guys.
Sir,
Yes, go ahead. Gemma, go ahead.
I am thinking um, personal injuries matter. Maybe the person wasn't necessarily found guilty of reckless driving on the criminal law, but some injury was done to someone else. So maybe the insurance company or something will pay the injured party. But under the state laws, they weren't found guilty of any criminal liability. You know. Did, did you hear me?
Yeah, no, I heard you. I'm trying to I'm waiting for the rest. So Jade argues that if there's insurance, then it would just be a contract claim. What do you think about that?
Well, I could see that point.
So does the injured party have a contract?
Not that I know, not in a personal case, in
Right.
personal injury case, not necessarily, but the driver of the vehicle would have a contract with the insurance company.
Right. But would the claim be a contract claim if the injured party has no contract? Right. So this is a concept that we call privity of contract, and you'll learn about it in your contracts courses. But basically, contract claims are limited to those who actually have the agreement. right? Who signed the agreement in some way, shape, or form. In order for contract law to reach out and affect people who didn't sign the contract, there are some exceptions to that doctrine. There are things like the third party beneficiary doctrine, and some other things that you will learn about in your contracts course. But beyond those fairly narrow exceptions, to be able to use a contract to find a contract law theory to approach a non-signatory, you would have to stretch the contract, right? So Jade says, doesn't the contract have a clause which shows that the injured party is to be paid by the insurance, and then the defendant has to have a higher premium? And the answer to that, right, is that it might, but that doesn't create a contractual right for the injured party. What it means is that the defendant has a contractual right to have the insurer pay whatever their liability is. Okay. But the injured party doesn't have a contract with the insurer. Now, I think you can create a contract doctrine that sort of generates these types of relationships. Okay, I'm not saying that you can't. I'm saying that I think that it requires some stretching of the rules of contract. Okay. So I think, I don't want to discourage you, Jade, from offering these sorts of solutions and answers to questions. I just want to make sure that we sort of understand that sometimes, in order for those to be correct, we have to acknowledge that we're talking about a world where we have changed the status quo. Okay, so does that make sense? Are we clear? Okay. The last thing that I want to talk about, and this will take a few minutes, and then we'll circle back to your questions, and we may wrap up a little early. The other thing that I want to talk about is I want to talk about redress. Okay, so Jade mentioned that if we move the management of tort cases into the criminal sphere, we say, okay, the DPP is going to be responsible for bringing cases that in the past would be brought in a personal injury venue. Jade made the point that, okay, maybe the injured party doesn't get paid, but they still get heard, and there's still redress, even if it's to the state. And I want to talk a little bit about that, because I said in the first week's lectures that the purpose of tort law is to appropriately allocate risk of harm. And if you think about tort through that lens, then I think Jade's point makes a whole lot of sense, right? That it doesn't matter how the tort fee, who the tortfeasor pays, as long as they pay. Because then they will internalize that risk of harm. Okay, and they will want to avoid having to pay. But there's another lens through which torts can be viewed that some folks mentioned in the lecture, right? And that lens is that the purpose of tort law is to make the injured party whole, right? To put you in the position as the injured party as if you had not been harmed. And if that's the lens that you see torts through, then I think that that raises a question of, does a payment to the state make you whole? Does it adequately compensate you? Does it repair the harm that was done to you? What do you guys think? Jade, you looked like you turned on your camera. It looked like you had something to say. Go ahead.
Oh no, I was just turning on. But I guess you can say that it compensates the injured party because you put them back in a state. But the process that you have to go through to get that money, I think sometimes makes it more difficult than just filing a criminal law case. Because the time that, say you're like a work incident, you fall off a lot at work, that case might take you a good 15 years to finally get paid, and that's only like $15,000, depending on where the injury is. Versus if it was a criminal law case, it would have gone through quicker.
That's certainly true, right? That the dragging out of the civil docket represents a problem, right? So I had, I used to tell my clients, and I practiced exclusively in federal court, where the judges move cases through, right? They move things along. There are scheduling orders for every case, and as soon as you basically, within 3 months of filing your lawsuit, you know when your trial is set for, and it's set 18 to 24 months out. Now, you will almost never proceed on that date. But cases get tried, 2 to 3 years after they're filed. And that's a fast moving docket, right? Jade made the point that some civil cases in the Caribbean may sit around for 15 years. I saw a judgment from the CCJ a couple of months ago where the CCJ admonished the lower court and the litigants, because this was an estate case and the estate had been open for over a decade. Nobody had any distributions. None of the property had been disposed of. It had all just sort of been sitting for 10 years, So coming back to Gemma, right? Gemma makes the point that paying the state doesn't restore the injured party. And I think that's right? And Alana, I think, is raising an excellent point that part of moving tort liability into the criminal sphere implies that there's some sort of social safety net where the state makes sure that that injured parties are made whole, right? So the state sort of becomes an intermediary and pays the victim and then pursues the perpetrator, right? In a way, if this sounds familiar, right, the state is essentially becoming an insurer, right? We're creating a subrogation system. If that doesn't make any sense to you, in your third year, you can take a class on the law of insurance, and that will everything will be made clear, right? But that's, that I think is sort of the requirement for that transition to be handled justly, is we have to recognize the compensatory component of tort law, and we have to make sure that the replacement system provides for that function. Okay. So you guys have done really great. This has been a really, really engaged and high-level conversation, and I really appreciate that. What questions do you guys have about what we've discussed today, or anything else that's come up in the class that you may not be clear on? Questions? Questions? Okay, nothing as yet. Okay. Questions going once? Questions going twice? All right. So we will wrap things up a little bit early today, and that's not a big deal, right? It's okay if we get through everything and we wrap things up a little early. That's so kind of you to say. I appreciate it. Please feel free to email the dean and tell him exactly how much you appreciate. No, don't do that. Don't do that. Don't do that. Like and subscribe. No. And I will see you guys tomorrow. So take care and bye. So.